If you go from the 1600s to the start of the 20th century, 47 states out of 50.
Now to our other top story, new laws will impact how you purchase and carry firearms in the new year.
Gun violence does not discriminate. It happens everywhere and all the time.
In response to the Supreme Court's decision to strike down a decades-old law that required a license to carry a handgun.
A new state law that bans carrying guns in most public places is set to take effect at midnight.
Historical context of concealed carry laws. The historical context of concealed carry laws in the United States traces its roots back to the drafting of the Second Amendment of the U.S. Constitution. The Second Amendment, ratified in 1791 as part of the Bill of Rights, states, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." This concise yet impactful statement has fueled centuries of legal debate and legislative actions regarding the rights of individuals to carry concealed arms. During the early years of the nation, there was a widespread acceptance of the idea that individuals had the right to carry weapons for self-defense. The notion of self-reliance and personal responsibility was deeply ingrained in the American ethos, and the right to bear arms was seen as a fundamental aspect of safeguarding one's life, liberty, and property. However, as the United States transitioned onto the 20th century, concerns about public safety and the rise of organized crime prompted a shift in attitude towards concealed carry. Various states began implementing restrictions on concealed carry weapons, requiring individuals to obtain permits or licenses. These regulations aim to strike a balance between individual rights and public safety, emphasizing responsible arm ownership. The debate over concealed carry gained renewed vigor in the latter half of the 20th century. In response to rising crime rates, some states adopted may-issue policies, granting authorities discretion in issuing concealed carry permits. Others moved towards shall-issue policies, mandating that permits be issued if applicants met specific criteria, shifting the emphasis from discretion to objective standards.
If you look at the history of gun carry laws in America, we have had them for hundreds of years.
In response to the Supreme Court's decision to strike down a decades-old law that required a license to carry a handgun.
If you go from the 1600s to the start of the 20th century, 47 states out of 50.
The watershed moment came with the landmark Supreme Court decision in District of Columbia v. Heller 2008. The court affirmed an individual's right to possess an arm for self-defense within their home, recognizing the Second Amendment as protecting an individual right rather than just a collective right related to malicious service. This decision set the stage for subsequent cases that would further define the scope of the right to bear arms. McDonald v. Chicago 2010 extended the Heller decision to the states, reinforcing that the Second Amendment applied not only to federal enclaves but also to state and local government. These decisions marked a seismic shift in the legal landscape, affirming the individual's right to keep and bear arms and placing a spotlight on concealed carry regulations. Despite these landmark decisions, some states, including California, sought to defy the Supreme Court's rulings. The enactment of California's SB 2 law, which imposed stringent concealed carry regulations in contradiction to the court's decisions, triggered legal challenges such as the V. Bonta case. This ongoing legal battle exemplifies the complex interplay between historical traditions, constitutional rights, and evolving societal perspectives on concealed carry laws in the United States. Landmark Supreme Court decisions. Landmark Supreme Court decisions play a pivotal role in shaping the legal landscape of the United States, influencing policies and interpreting the Constitution. These decisions often mark turning points in history, addressing fundamental issues and setting precedents for future cases. Examining the historical context, significance, and impact of such rulings provides a deeper understanding of the evolution of American jurisprudence. One of the landmark decisions that significantly shaped constitutional interpretation was Marbury v. Madison, 1803. Chief Justice John Marshall, in delivering the opinion, established the principle of judicial review, asserting the Supreme Court's authority to review and potentially invalidate government actions deemed unconstitutional. Landmark decisions have also shaped individual rights and liberties. Miranda v. Arizona, 1966, is a notable case that established the Miranda warning, ensuring that individuals are informed of their constitutional rights when taken into police custody. Chief Justice Earl Warren emphasized the protection of the Fifth Amendment privilege against self-incrimination, transforming police orders, and safeguarding suspects' rights during interrogations. In the realm of reproductive rights, Roe v. Wade 1973 remains a landmark decision. The court, in a 7-2 decision, recognized a woman's constitutional right to choose to have an abortion. Justice Harry Blackmun, writing for the majority, outlined a trimester framework balancing a woman's right to choose and the state's interest in protecting fetal life. Roe v. Wade sparked extensive legal, political, and social debates that persist to this day. Landmark Supreme Court decisions encapsulate the evolving understanding of constitutional principles and reflect the dynamic nature of American society. These rulings not only impact legal doctrines, but also shape societal norms, contributing to the ongoing dialogue about the balance between individual liberties and government authority. As the court continues to confront pressing issues, future landmark decisions will inevitably play a critical role in defining the nation's legal landscape. Concealed carry legal battle. The significant legal development surrounding California's concealed carry law and its clash with a recent groundbreaking Supreme Court decision, likely referring to New York State Rifle and Pistol Association v. Bruin. This case saw the Supreme Court striking down New York's May-issue concealed carry licensing scheme, establishing important principles and guidelines for concealed carry laws. The subsequent actions of California, specifically the passing of Senate Bill 2 or SB 2, are presented as a direct challenge to the principles outlined by the Supreme Court. SB 2 introduces several restrictive measures related to concealed carry permits in California. These measures include an increase in training requirements, changing the class requirements for new applications, and renewal hours. Moreover, the law introduces a subjective good moral character assessment by law enforcement agencies, potentially allowing them to deny applications based on this vague criterion. Such measures not only defy the spirit of the Supreme Court's decision in Bruin, but also go further by imposing even stricter regulations than those in place before. A federal district court judge, Judge Cormac Carney, is reported to have issued a preliminary injunction against certain provisions of SB 2. The preliminary injunction is seen as a major legal victory for advocates of Second Amendment rights, particularly those supporting more permissive concealed carry regulations. It suggested that the judge found these specific provisions to be inconsistent with the recent Supreme Court decision and consequently issued the injunction to prevent their enforcement. Despite this legal setback, California has swiftly responded by filing an emergency stay seeking to challenge or reverse the preliminary injunction. This indicates the state's determination to defend its restrictive concealed carry regulations and contest the federal court's interference. The legal battle is framed as a clash between state-level regulations and the constitutional rights protected by the Second Amendment. The broader implications of this legal dispute, hinting that the outcome may have consequences not only for California, but potentially for concealed carry laws nationwide. The Ninth Circuit Court is mentioned as the next venue where this legal drama will unfold, suggesting that the case is likely to progress through higher courts. In general terms, ongoing legal saga highlights the dynamic nature of the legal landscape, reflecting the broader national debate on arms rights and the interpretation of the Second Amendment. The clash between state-level regulations and constitutional rights becomes the focal point, with the outcome of this legal battle poised to shape the future landscape of concealed carry laws in California and potentially influence similar laws in other states. Second Amendment struggle. The right to keep and bear arms for self-defense has been a fundamental aspect of American constitutional rights for many years. However, for a significant period, this right was often relegated to a second-class status. It was only through landmark decisions by the United States Supreme Court, such as D.C. v. Heller, McDonald v. Chicago, and more recently the Bruin case, that the significance of this right was underscored and its relegation could no longer be tolerated. In these decisions, the Supreme Court made it unequivocally clear that individuals have the right to bear arms for self-defense, and this right is inherent to their very humanity. The court rejected the notion that law-abiding citizens should be prevented from carrying handguns, emphasizing that the Constitution, by design, recognizes certain rights as so important and sacred that nothing short of a constitutional amendment could infringe upon them. The recent legal battle in California, particularly the case of Doe v. Bonta challenging the newly enacted SB 2 law, reflects the ongoing struggle to protect and uphold the Second Amendment rights of individuals. SB 2, which is set to take effect on January 1, 2024, was passed in defiance of the Supreme Court's decision in Bruin. The law imposes stringent restrictions on concealed carry permits, including increased training requirements and limitations on the areas where individuals can carry. The heart of the legal challenge lies in the restrictions on carrying in specific locations, effectively rendering the concealed carry permits almost useless.
These laws come into effect in the aftermath of mass shootings that have rocked the state and nation.
Had laws restricting or barring concealed gun carry, and some states had laws barring open carry.
Now to our other top story, new laws will impact how you purchase and carry firearms in the new year.
The law designates almost every place in California as a sensitive location, restricting the right to carry in areas like hospitals, public transportation, places where alcohol is served, public gathering areas, playgrounds, parks, casinos, stadiums, public libraries, amusement parks, zoos, museums, churches, banks, and even private businesses unless explicitly allowed. The federal district court, in a significant win for Second Amendment advocates, granted a preliminary injunction against various aspects of SB 2. Judge Cormac Carney, in his decision, emphasized the importance of the right to self-defense and the historical and constitutional foundation that supports it. He refuted the notion that law-abiding citizens should be denied the ability to carry handguns and pointed out the lack of historical support for the extensive carry limitations imposed by SB 2. However, the legal battle didn't end with this victory. The state of California, determined to enforce the restrictive SB 2 law, immediately filed for an emergency stay, seeking to overturn the preliminary injunction. The Ninth Circuit, known for its historical reluctance towards Second Amendment rights, became the battleground for this crucial legal fight. As attorneys for Michelle and Associates worked tirelessly over the holidays to respond to the emergency stay request, the outcome remained uncertain. The Ninth Circuit's motions panel, responsible for reviewing the emergency stay, requested additional briefing, adding complexity to an already challenging situation. The legal teams engaged in a race against time, with the fate of California's concealed carry restrictions hanging in the balance. The likelihood of the emergency stay being granted by the Ninth Circuit remains uncertain. Legally, such stays are intended to maintain the status quo, but California is seeking to change the law entirely, making it an exceptional case. The Ninth Circuit's historical stance on Second Amendment issues adds an additional layer of complexity and uncertainty. In some position, the legal battle over California's concealed carry restrictions reflects the ongoing struggle to balance Second Amendment rights with public safety concerns. The recent court decisions and the subsequent emergency stay request highlight the challenges faced by those seeking to protect the right to bear arms for self-defense. The outcome of this legal battle will have significant implications not only for California residents, but also for the broader interpretation and application of the Second Amendment across the United States. Second Amendment victory upheld. In a significant legal development, a federal judge has issued a preliminary injunction blocking a California law set to take effect on January 1st, which aimed to ban carrying arms in numerous public places. The ruling, made by U.S. District Judge Cormac Carney, is grounded in the judge's assertion that the law violates the Second Amendment of the U.S. Constitution and infringes upon individuals' capacity to protect themselves and their families. The law, signed by California Governor Gavin Newsom in September, was poised to prohibit the carrying of concealed arms in 26 designated locations encompassing public parks, playgrounds, churches, banks, and zoos. Crucially, the ban would be applicable irrespective of whether an individual possesses a permit to carry a concealed weapon. Notably, privately owned businesses could allow arms on their premises by displaying signs indicating such a permission. Judge Carney's preliminary injunction offers a temporary halt to the implementation of this law, emphasizing its broad scope and its alleged contradiction of the Second Amendment, as well as defiance of the Supreme Court. The judge's words reflect a belief that the law, as it stands, would unduly curtail citizens' rights to bear arms for self-defense, a constitutional privilege that courts have increasingly protected and clarified in recent landmark decisions. The legal battle against the law will continue, and the judge anticipates that armed rights groups, particularly represented by the California Rifle and Pistol Association, are likely to succeed in proving its unconstitutionality. This suggests that the law may eventually face permanent overturning, marking a significant victory for Second Amendment advocates. The context of this legal saga involves the aftermath of the U.S. Supreme Court's decision in New York State Rifle and Pistol Association v. Bruin. This decision, which prompted several states to reassess and modify their gun laws, established a criterion for evaluating the constitutionality of such laws based on their alignment with the nation's historical tradition of arm regulation. The California law under scrutiny was a response to this judicial precedent and sought to overhaul the state's rules regarding concealed carry permits. The judge's determination that the law is likely unconstitutional underscores the ongoing tension between arm control measures and individual arm rights in the United States. This tension isn't new, as courts grapple with striking a balance between public safety concerns and protecting citizens' rights to bear arms for self-defense as enshrined in the Second Amendment. The ruling is a notable victory for those who advocate for a robust interpretation of the Second Amendment. It reaffirms the principle that any legislation attempting to restrict armed rights must navigate a careful path to avoid running afoul of constitutional protections. As the case progresses, it's likely to be closely watched, as it could contribute to shaping the ongoing discourse around armed rights and regulations in the United States. Second Amendment conquest. The recent federal judge's decision to block a California law aimed at restricting concealed carry in public places has ignited a legal and political debate around armed rights, the Second Amendment, and the authority of states to regulate arms. The ruling, coming in response to the state's attempt to implement SB 2, has implications that extend beyond the specific case to broader discussions about arm control, constitutional rights, and the role of the judiciary. California's SB 2, signed into law by Governor Gavin Newsom, sought to impose significant restrictions on carrying concealed arms in public spaces, including parks, churches, banks, and zoos. The law was set to take effect on January 1, 2024, but U.S. District Judge Cormac Carney intervened by granting a preliminary injunction against it. The judge's decision rested on the assertion that SB 2 was a violation of the Second Amendment, which protects the right to keep and bear arms. The legal battle has its roots in the Supreme Court's recent decision in New York State Rifle and Pistol Association v. Bruin. In Bruin, the court struck down New York's restrictive concealed carry licensing scheme, emphasizing the individual's right to self-defense and the need for regulations to align with the nation's historical tradition of armed regulation. California, however, proceeded to pass SB 2, prompting legal challenges from various groups, including the California Rifle and Pistol Association. The judge's emphasis on the right to self-defense and the impracticality of the proposed restrictions, such as making every public area a sensitive location, resonates with those advocating for broader arms rights. On the other hand, California's progressive leaders, including Governor Newsom and Attorney General Rob Bonta, expressed disappointment with the ruling. They argue that the decision jeopardizes public safety by allowing arms in places where families and children gather. Newsom, known for his strong stance on arm control, labeled the ruling as defying common sense and threatening the safety of spaces that should be gun-free. The legal battle is far from over, as the state has indicated its intention to appeal the decision. The Ninth Circuit Court of Appeals will play a crucial role in determining the fate of SB 2 and, more broadly, the extent to which states can regulate concealed carry in light of the Bruin decision. The case highlights the ongoing tension between states' efforts to implement arm control measures and the constitutional protections afforded to individual gun owners. As the legal proceedings continue, the ultimate resolution could shape the landscape of concealed carry laws and the interpretation of the Second Amendment in the years to come. Second Amendment's expansion. The Supreme Court's recent ruling on New York's concealed carry law marks a significant moment in Second Amendment jurisprudence. The 6-3 decision, with Justice Clarence Thomas delivering the majority opinion, struck down the state's long-standing law that required individuals seeking a concealed carry license to demonstrate a proper cause for self-defense. The court held that this requirement violated the Second Amendment rights of law-abiding citizens. The court emphasized that any restrictions on the right to carry must align with the nation's historical tradition of arm regulation. This set the stage for the recent ruling on New York's concealed carry law. In essence, the Supreme Court, through these landmark decisions, has reinforced the idea that the right to self-defense is inherent in the Second Amendment. The right to bear arms is not a second-class right subject to stringent regulations that go against historical norms. The court rejected the notion that law-abiding citizens must demonstrate a special need for self-defense, equating it to requiring a special need for the exercise of other constitutional rights. The California case challenging concealed carry restrictions also aligns with this broader legal context. The preliminary injunction granted by Judge Cormac Carney against various aspects of California's new concealed carry restrictions echoes the sentiment that the right to self-defense must not be unduly burdened by excessive regulations. The recent Supreme Court ruling striking down New York's law is a significant victory for advocates of Second Amendment rights. It underscores the principle that citizens have a fundamental right to bear arms for self-defense, not just within their homes, but also in public spaces. The decision also signals a shift in the court's approach to evaluating gun regulations, emphasizing a historical perspective and recognizing the importance of the right to self-defense in contemporary society. However, the legal battle is likely to continue as state officials in New York express their intent to appeal the decision. The broader implications of this ruling may influence concealed carry laws in other states, prompting a reevaluation of regulations that may infringe on the constitutional rights of law-abiding citizens. Implications and debate. The recent Supreme Court ruling on carrying arms in public has sparked varied reactions and discussions across political, legal, and societal spheres. Mayor Eric Adams of New York City expressed concern about the potential risks the ruling might pose to the city's safety, emphasizing the need for a comprehensive reassessment of arm restrictions and licensing processes to ensure qualified individuals are the only ones granted licenses. Former President Donald Trump credited the ruling to his judicial appointments, underscoring the significance of judicial selection and its impact on upholding constitutional rights, particularly the Second Amendment. The decision underscores the divergence among states regarding concealed carry regulations. While around half of the states require a state-issued permit for carrying concealed arms, some states like California, Hawaii, Maryland, Massachusetts, New Jersey, and Rhode Island strictly limit public carry based on specific needs, giving officials discretion in licensing decisions. Throughout the court proceedings, New York officials and the Biden administration cautioned against the far-reaching implications of invalidating the law, expressing concerns that it could set off a chain reaction, potentially challenging other restrictions in places where crowds gather, such as airports, arenas, churches, and schools. During the hearing, justices explored the potential ramifications of a board ruling on arm restrictions in areas with significant public congregations. Chief Justice Roberts queried about the possibility of banning arms at venues like football stadiums or places serving alcohol, while Justice Barrett raised questions about limiting guns in sensitive locations like Times Square during New Year's Eve celebrations. Justice Alito, in a concurring opinion, critiqued Justice Breyer's dissent for focusing on recent mass shootings. Alito questioned the efficacy of laws like New York's in deterring or preventing such tragic events and pointed to specific instances where stringent laws didn't prevent violence, citing a mass shooting in Buffalo despite existing restrictions.
A new state law that bans carrying guns in most public places is set to take effect at midnight.
This decision has made every single one of us less safe from gun violence.
Gun violence does not discriminate. It happens everywhere and all the time.
The ruling has generated considerable attention and discussion across various media platforms, reflecting the ongoing debates around gun laws, individual rights, public safety concerns, and the judicial interpretation of constitutional provisions. The decision's implications and debates over arm regulations continue to trend in news and public discourse, highlighting the complex and contentious nature of Second Amendment rights and their intersection with public safety concerns. And that's going to do it for this video, guys. See you next time, and bye for now.